Welcome to the Law and Crime Network. We have been live in the Wallace Bradsher courtroom today watching testimony of Cindy Blitzer's supervisor, which has been pretty critical to the case. By this testimony, her supervisor said that he delegated all of his tasks for recording her time to Bradsher, who apparently never really did that, never assigned it to anyone on an administrative level to keep track of that time, and ultimately was hiding the fact that Cindy Blitzer was not actually working, but was still collecting a $48,000 a year paycheck. Right now, we were just listening to testimony from a previous day of trial. This was the testimony of David Whitley. He's the lead investigator on the case. And he was talking a bit about how this unfolded, how it came to light that Cindy Blitzer was actually not working and that Bradsher was really covering up for this. Now, this has been couched by the investigators as what they're calling a wife swap, a scheme concocted between these two former district attorneys, Wallace Bradsher and Craig Blitzer. These names are tongue twister, but we'll get through it, to both hire each other's wives to work for them. This is to get around ethical rules which say that their wives could not work for them directly or family members couldn't work for them directly. In doing this, though, apparently, as per the allegations in this case, Cindy Blitzer was actually not working but was still getting paid. The prosecution has said that this is just absolute disloyalty to the community and just a complete breach of public trust, and that's the direction that they're going. But there's a lot to unpack in this case. There are quite a few twists and turns that have come about through the trial. So I really want to get into this with Michael Bachner. Now, he is a white-collar criminal defense attorney, and we have him here in studio. Michael, thank you so much for joining us today.
My pleasure to be here.
It's really, this case has a lot of interesting aspects because we have a few different things at play here. First of all, what do you make of Wallace Bradsher representing himself, keeping in mind that he was ingrained in this community as the district attorney?
Well, the old line is a person who represents himself as a fool for a lawyer. But at the end of the day, there is a method to that madness where you are the defendant in the case and you're a lawyer and you're experienced in what you do. Number one, he may feel that no one can do a better job than me in cross-examining these witnesses for whom I worked so long and who may have some subconscious respect for me and maybe not want to hurt me, number one. Number two, it alleviates the need to testify on your own behalf. Most defendants don't testify. They don't want to subject themselves to cross-examination. So when you are doing the examinations yourself, you're actually getting your story to the jury. You're doing all that to the jury. You can sum up to the jury. You can open to the jury. But you never have to testify. You never have to be cross-examined. So there's a way of doing that as well. So there's only one other case I know in which a lawyer represented himself in a massive federal insurance fraud case in Florida. He was the only one who got acquitted out of 10 defendants.
Well, that's interesting. So it can work out sometimes. As you said, that old adage, you hear that all the time. But maybe in this case, it could work in his favor. To your point, Michael, I noticed something interesting during the testimony of Judge John Schultz, who was Cindy Blitzer's supervisor. Now, when he was on direct examination, of course, he's laying the foundation, the timeline, the story. But on cross-examination, Bradsher saying to him, didn't we have this conversation on this day? Didn't you and I discuss this at this time or another time? I thought that was interesting. And what do you think a jury makes of that? I mean, who knows this case better than him?
Well, that's true. And that's the method of a person, the defendant, actually being able to get his story across without having to testify and basically saying, well, you and I had this discussion, and thereby getting his testimony forward. There are issues with lawyers kind of insinuating themselves into a case, and if this were a prosecutor or a real defense lawyer and saying, didn't you and I have a discussion, there's issues there about you bolstering your own credibility in the course of the trial, but it's a way of getting his story out, and no one's objecting, apparently. So.
Yeah, I didn't hear any objections. It's funny, because as that was unfolding, I'm listening. I'm like, I think I might have put an objection down on the record there.
I think I would too.
Just to make sure you preserve those issues. Yeah. So while there might be some benefits, and as we discussed, oftentimes it can be to someone's detriment to represent themselves. Now, we know at the beginning of the case that actually Bradsher had an attorney, that he was offered a plea deal. He fired that attorney and said, I'm going to trial. He also made some motions to remove a judge from the bench, to say that the district attorney who was going to be prosecuting the case was biased. That district attorney stepped down voluntarily, and a new district attorney came in. Now, that can be something, correct? Because you're talking about relationships, deep-seated relationships in this legal community that Bradsher does have with these folks. So is that a problem, or can that be beneficial too? I mean, of course, judges are supposed to be neutral, but you know this guy for 20-some years.
Well, you know, yes, that's all true, and you're hoping that judges. I'm surprised. This is a jury trial too, right?
Yes.
It's interesting that, you know, Bradsher could have waived a jury, I imagine, and just tried this case in front of a judge if he wanted to. But at the end of the day, it's not uncommon for these types of cases to actually be put out to what we've all heard the term now, special prosecutors, or to the Attorney General's office. You have that going on here in New York in some cases as well, where if they find out that Cy Vance, for example, in the Weinstein case, they found should not have been investigating a case in connection, I'm sorry, not Weinstein, the Schneiderman case, the Attorney General's office, so it got sent out to another individual to try it. But it is odd. Maybe this is just a little bit of a smaller town, so they kept it local.
It's a bit of a smaller community, so it's local, but it will be interesting to see how all of these issues play out. Michael, we have much more to unpack here on this case, but in the meantime, I do want to review more of the lead investigator, David Whitley's testimony. Now, his testimony is critical to the case and really lays out the timeline about how this issue with Cindy Blitzer was discovered and how it came to be that Bradsher was actually called into question with respect to how he was handling her employment. So we're going to continue with that testimony now while we wait for court to come back in session from lunch. We're watching the testimony of investigator David Whitley. This is in the Wallace Bradsher case. We're live in the courtroom there today. The court is now on a lunch break. So we're here with Michael Bachner talking about and breaking down all of the aspects of this case. So Michael, we've seen testimony of the lead investigator. We've seen testimony from the other district attorney who was involved in the case. We've now seen testimony from Judge John Schultz, which called into question something you and I were talking about on the break. Who was really responsible for recording this time and making sure that it was accurate and that it was put into the system accurately to be paid accurately, right? So that's really what this comes down to in my mind. Now, interestingly enough, during Judge John Schultz's cross-examination, again, by the defendant himself, the defendant made that point. He said, well, isn't it ultimately your responsibility to do this? And Schultz kind of wavered. What do you make of that? Do you think that the jury is going to see that and say to themselves, well, hey, maybe he was the guy who should have been overseeing this whole thing from the get-go?
At the end of the day, the analysis is going to be if she worked the hours she was supposed to work, then nothing happened. If she didn't work the hours she was attesting to in her information that she was working, and if that attestation is false, the fact that someone may have erroneously entered into the system really doesn't matter. However, to the extent that there is an indication there that she did work that time, you can certainly make hay in front of a jury, and if a jury is inclined perhaps to cut a break, then they may use that as a kind of what we call jury nullification, basically saying, you're all crazy, I'm not going to convict her over something like this. But as I understand it, Mrs. Blitzer was, in nursing school, full-time, 72 miles away from where she was supposed to be working. So in the final analysis, if she's not at the job and she's swearing that she was, whether someone was entering it erroneously is an issue. Now, if someone's purposefully entering the fact that she's working when she shouldn't have been working, that only makes two people responsible. It's not really a defense to whether she was working.
Right, and that makes sense. And perhaps Bradsher was making that point because he wanted to get that out there, have the jury hear it, and perhaps take that into consideration. But as you said so articulately, it really comes down to whether or not there was a conspiracy here, whether or not he was knowingly doing this, whether or not that was the issue. That's really what it comes down to. What I have been grappling with since the beginning of this trial is just the question of what's Bradsher, Wallace Bradsher, getting out of this arrangement? Because we remember his wife was also working for the other district attorney who has taken a plea deal. But the investigators concluded that she was working. You know, she was working the hours that she said she was working. She was performing that service for the office, and she was paid accordingly. So there's really no the idea of the quid pro quo type deal that it seems to be that lingers in the courtroom. That doesn't seem to be there. So why is Bradsher covering for this woman?
Well, I mean, there is the ethical issue that they were kind of trying to avoid the ethical issue that you couldn't work for someone related. So they said, well, we'll just switch it, and she'll work in your jurisdiction, and your wife will work in my jurisdiction. What it seems like Bradsher's getting out of it is, although his wife may actually have been working, to the extent that Blitzer's wife wasn't working, it would seem that there was an agreement that, you know, if Blitzer's wife wanted to work, that would have been fine too. I don't think the agreement was, I'll give her a no-show job. I think the agreement was that we'll just work for each other, and when Mrs. Blitzer obviously decided that that wasn't going to fit into her otherwise busy school schedule, I think what happened is they decided we're just going to cover for each other, because Bradsher was happy with his wife working and getting paid, when probably there was an issue whether she should have been working there at all too, from an ethical issue. But yeah, what is he getting out of it? He's getting out of it my wife getting a job that maybe she otherwise wouldn't have had, and from the other side of it, he's covering for this person. Perhaps there was the threat that I'll fire your wife if you don't keep my wife on. At the end of the other prosecutor did enter a plea of guilty. So any argument by him that, you know, I didn't know it was wrong, or, you know, it's just not going to cut it.
Yeah, and that's what I think is so interesting, Michael, because Blitzer, who did take the stand and did say that he questioned this arrangement. Mm-hmm. Oh, I kept asking. Doesn't it seem strange? She's not working on these special projects she's supposed to be working on. She's not doing this or that. Oh, I kept questioning it. And Bradsher kept saying, oh, it's all right. Don't worry about it. I have full autonomy to make decisions about the way my staff, when my staff works, how my staff works, and whatnot. But see, to me, what the point you brought up, that doesn't hold water to me, because obviously this man's an attorney. He knows that to say, like, oh, I didn't know, except Bradsher told me it was okay, that doesn't sound like enough. This sounds like somebody who's taken a sweetheart plea deal and is testifying in accordance with that deal.
Well, he's a prosecutor. He knows that this arrangement where his wife is not working is not right, if in fact it's true. And there is something, not only does he have actual knowledge that his wife is being paid for a job that she's not attending, and there's no way that you could possibly believe that it's okay for a person to be on the public till and getting paid for work that she's not performing at all. It's not that she's performing it poorly, she's just not there. That just doesn't wash. And there's also something in the law generally, federally anyway, called conscious avoidance. I don't know if it fits into this state law, but conscious avoidance basically means if you stick your head in the sand, it's just like you knew, and you can't just say, well, I thought it was all okay. All these red flags are telling you, and you know, because you live with this woman, that she's going to school and not working. You know a crime's being committed. And but of course, the issue for him is, if his wife is working and not getting paid, the crime is hers. It's not the husband's. So he pled guilty. By him pleading guilty, there had to have been an understanding between him and Bradsher that this was going to happen, because his liability, his culpability has to be based on his intentions, not his wife's. So if his wife committed a crime, that's one thing, but the fact that he pled, and interestingly his wife didn't, but the fact that he pled meant that he had an agreement with Bradsher whereby they knew that a crime was going to be committed.
And that's really the crux of this case, right? So we can go back and forth about some of these different facts that don't necessarily seem to add up, but when you're talking about obstruction of justice, conspiracy, what do we need to show in order to convict Bradsher in this case?
Well, for an obstruction, you have to demonstrate that, and we all know this from the press that's going on around us.
Yes, I think everybody in America knows this legal standard at this point.
Obstruction just basically means you have to demonstrate that there is some type of ongoing investigation and that you're taking efforts to interfere with the investigator's ability to perform that function. That is an obstruction. That's an obstruction of justice.
And so as far as conspiracy, as you said, and that really plays into the fact that we have Blitzer. Right. Blitzer has made a plea arrangement, and so he's testifying against the defendant. And in doing so, is that conceding that there was some sort of agreement, or is that a difficult issue to overcome for the defense here? Well,
that's a really good question, actually. Conspiracy, just for the audience, just simply means an agreement between two people to commit a crime. And that an overt act, a step is taken to further the commission of that crime. And that act can even be an innocent act. So if you and I agree to rob a bank and I go rent a car, we now have a conspiracy to rob a bank, even though the bank is never robbed. The conspiracy is punished separately from the actual, what we call substantive offense, the actual bank robbery. So the conspiracy would just be Bradsher and Blitzer agreeing with each other that they will swap wife jobs, knowing that it's improper and knowing one may not be working or some impropriety is being committed, and that an act is committed. So there you have the conspiracy. But what's interesting is generally at trials, a judge will actually instruct a jury at the request normally of the defendant the fact that a person has pled guilty to a conspiracy and is cooperating is not evidence of the guilt of the defendant. So the fact that I say I was involved in a conspiracy with you, the judge will tell the jury, you may not infer that there was such a conspiracy merely by the fact that he pled guilty to it. You have to look at what his evidence is, what his testimony is. The fact that he pled guilty is a personal decision about what he thinks he did wrong, but is not evidence about what the defendant did.
Michael, thank you so much. To have your expertise in this case specifically is really helpful because there are so many different pieces to this puzzle to put together, especially given the dynamic between the two. You have two former friends, two former colleagues. One's pled guilty, the other is defending himself. So there are a lot of different aspects to this case that are making this trial really riveting to watch. So while we wait for court to come back in session, again, they were on their lunch break. They left about 12, so we anticipate in the next 20 minutes or half hour or so that we'll be back live in the courtroom. We're going to continue to watch the testimony of the lead investigator, David Whitley. Now, this testimony is really critical to the case because it's laying out the timeline, which really matters here because it relates to when Cindy Blitzer began her employment and how it all unfolded and came to light that Cindy Blitzer was actually attending a full-time educational program of nursing school while maintaining a full-time job at the office. So we're going to cut to this testimony, David Whitley, while we wait for court to come back in session. Thank you for joining us this afternoon on the Law and Crime Network. We're live in the courtroom of Wallace Bradsher. Right now, court is not in session. They're on a lunch break. We anticipate that court will be live again in the next 15, 20 minutes, and we're keeping an eye on that, and we'll make sure to bring you live into that courtroom the moment we know that they're back in session. In the meantime, we're reviewing some critical testimony from the past week of trial. Today is actually day 7. So this is David Whitley. We were just watching his testimony. He's the lead investigator in the case, really setting the roadmap here for what the prosecution intends to prove, which is that Bradsher is guilty of obstruction of justice, conspiracy, and failure to discharge his duties of office, among other allegations. So that's where we are right now. Again, an interesting twist in this case. Bradsher is representing himself, which can be to the detriment sometimes of the client, who is yourself. So that's interesting to see how that is playing out. He's cross-examining witnesses who were actually former friends and colleagues of his. So that is adding an interesting dynamic to the trial. In addition to that, we know that recently there has been a civil whistleblower suit brought. Now, this is a civil case brought by a former employee, Deborah Halbrook, and she says that when she exposed the fact that Cindy Blitzer was not actually performing duties and was getting paid, when she exposed this wife swap deal, Bradsher terminated her. So that serves as the basis for a whistleblower suit, meaning she complained about an illegal activity and she was retaliated against for making a complaint. So in response, what we've just seen is that Wallace Bradsher has wasted no time, but he did bring a defamation suit against Holbrook. So how does this all factor into the criminal trial that we're watching right now? Well, we have an expert here to talk about it. Michael, let's talk about what is the impact of a civil case on a criminal case, just generally, outside of the facts of this specific case, but what does that mean for a criminal case?
Well, usually, if there are what we call parallel proceedings occurring, and if there is a defendant in a criminal case can use a civil litigation as a device to get discovery, that is information regarding the charges in the criminal matter that he ordinarily would have had to wait to get in the criminal case by using the civil processes. And also, in most jurisdictions, you're not entitled to what we call depositions in a criminal case, meaning you don't get a chance to ask the witnesses before the trial questions. In a civil case, you do have that avenue. So by bringing a civil lawsuit, it permits Bradsher to have access to information that he ordinarily would not get in his criminal case. So it is an avenue for him to get this additional discovery, this additional information. So that's one avenue. But other than that, it's also an act by him, I think, to demonstrate how aggressive he is, how he's not going to let anyone take these positions, how he's going to fight everything, that he's been harmed. And I think it's just an indication for him to put out there that he is the aggrieved party here and that everyone is out to kind of get him.
Right. You bring up some interesting points because we see in the lawsuit that Bradsher has now brought against this woman who is bringing the whistleblower suit. You see that it's defamation, racketeering, obstruction of justice, abuse of power, civil conspiracy, all of those allegations stemming from his theory, which is that this is just a money grab for her, that she's looking to use this situation to make a buck. So that's the basis for his complaint. Of course, defamation is the primary claim that he's making. But I want to bring up something interesting that you said, because obviously, although you have these are two separate cases, one's in a civil court, one's in a criminal court, different standards, a preponderance of the evidence versus beyond a reasonable doubt. So while there is overlap, they are still two separate proceedings. But one thing our viewers are probably wondering, because I always think of this too, the impact of, like you said, deposition testimony. Well, if there's depositions, that's going to lock Bradsher into certain statements. We saw how that worked out for Bill Cosby, right? That's the prime example of how a civil case can actually have a very strong impact on a criminal case. Now, this is a newer case, so the criminal trial will likely be concluded before before the depositions even begin. It's a little bit slower. But is that a risk that a defendant has in this situation?
Yeah, it's a huge risk. Usually what happens is it's the defendant who's been sued while there's a criminal case going on. This is converse, where the defendant is the plaintiff. So generally speaking, it's the other way around. And we have an example just in what's happening now in what's occurring in the Trump administration issues. You have Michael Cohen, who had originally brought a civil suit against BuzzFeed and against Stormy Daniels in connection with what he said were defamatory statements made about him. As soon as he became the target of the criminal investigation, he then withdrew those civil suits because he knew that he couldn't participate in them because he couldn't be deposed. He couldn't become a witness. And if you're not going to agree to be deposed when you're the plaintiff, the case gets dismissed because you have Fifth Amendment rights, et cetera. This is a very aggressive move by Bradsher. I guess he figures, my story's not going to change. I don't care about being deposed. And if Holbrook ever is a witness in his criminal case, he wants to be able to cross-examine her about the fact that you sued me and I sued you. I'm sorry, I sued you over what you said. I've charged you with defamation. And he could be on the essentially be aggressive with her and try to demonstrate that he wasn't putting up with any of what he considers her nonsense or her false lawsuit.
Well, that's interesting, Michael. That's a great point. And I didn't think of that before, because we have Holbrook who's saying that she was terminated by Bradsher, and this is in January 2017, for reporting him to the State Bureau of Investigations regarding this incident, saying that Cindy was allowed to collect paychecks without having to work. So she's saying she reported this incident and shortly thereafter was terminated. Now, it looks like from the reports that we've seen, she had been a longtime employee. She was just shy of retirement. She said she had an excellent performance review the year before. Bradsher said she was terminated for poor performance. So there's a lot of aspects there that relate to the civil trial. But you bring up a great strategy as a defendant. Because now, can you talk about that defamation complaint in a cross-examination on the stand?
Absolutely, because it goes to motive. The fact that she brought the suit goes to her bias and motive as against him. It demonstrates that she's really out to collect money, and there's a monetary basis for her to be testifying, to trying to collect money. And he can now cross-examine her about the fact that you brought this suit and I brought an action against you for defamation because I wanted the world to know and the courts to know that you're a liar. So it shows this very aggressive posture by him. And it's very clear in the way he's defending himself, going on his own pro se, as we call it, to represent himself, that this is a lawyer who realizes it's scorched earth here because if I get convicted, my career is over and I'm likely going to be going to jail. So I think he's just pulling out all the cards here and trying to convince a jury that this is not how the way an innocent person acts is you sue me or you bring a whistleblower suit, I sue you back because I'm not going to stand for that. It's a very tough road to hoe, but it's an interesting strategy.
And we do know that at the onset of this case that he was at one point offered a plea deal. I don't know the details of that plea deal, whether or not it's something that he had considered. And he was represented by another attorney, but he fired that attorney and said, I want to go all the way. So that fits in with your theory. And I agree with you, Michael. I think that he's probably using the fact that he had this defamation suit as leverage in this case, because I would imagine that Holbrook, and we can check the witness list to the extent that we have them here, she seems like she would be a critical witness, correct? If she's one of the people that's reporting to investigators?
Absolutely.
The fact that she identified this issue and wasn't getting paid. So should we anticipate seeing her on the stand?
Yeah, if she's not on the stand, he can certainly, if he wanted to, and I'm not sure about, I don't know the facts well enough to know if it's in his interest or not, he could elicit the fact that the investigation was instigated by her. He could certainly bring that out, but I'm expecting that that she's the kind of witness who would come forward and so what did she see? What instigated this? What caused her to believe that Blitzer wasn't working? Did you ever see her there? Was she ever in the office? You know, things of that nature. So I'm expecting that will come forward.
Certainly those would absolutely be critical questions that we anticipate will be answered as this case continues to unfold. We are still in the midst of a lunch break in the courtroom, but while we wait for the courtroom to be back in session, which we do anticipate will be in short order, we think in the next 20-25 minutes we'll likely be back live. In the meantime, we're going to cut to a commercial break now, and then we'll have more with Michael. Thank you for joining us on the Law and Crime Network this afternoon. We are waiting for the Bradsher case to be back in session. Right now, they are on a lunch break. But while we wait, we'd like to talk about a trial of a tragic incident that we anticipate opening statements will begin tomorrow. This is Kentucky versus Canada embolism. This is going to be a heart-wrenching trial. These two men are facing the death penalty in the killing of a Marine. So the two are accused of killing Jonathan Price and injuring his wife Megan in a Lexington shooting in June 2014. The allegations are that the couple was at a local bar celebrating Megan's birthday. As they exited, authorities say that the two men approached them, attempted to grab Megan's purse, and Jonathan intervened. After a fight broke out, Jonathan was shot in the back and Megan was shot in the leg. These two men are now facing the death penalty. I want to bring Michael in to talk a little bit about this case. Michael, obviously we haven't heard opening statements yet. We know that opening statements are set to go forward tomorrow. The jury has been selected. But in a case like this, obviously this happened outside of a bar. What types of evidence do you think we're going to see? I mean, cameras are everywhere these days. Do you think we're going to have this caught on video?
There's certainly a decent chance. We live in a world where, like you said, virtually everything's videoed or someone's out there with a cell phone camera. But you know, you're going to have issues about how inebriated people were. Was this a robbery that was premeditated, or were these two drunks, two guys who had too much to drink and saw something of opportunity and did something where there's some degree of mitigation to the conduct? Those types of incidents are going to be coming out. But when you hear about a Marine who's dedicated his life to protecting the country and puts himself in harm's way, potentially in a foreign country, and lives through it, and comes back here and gets shot with shot in a robbery. How horrible, potentially, how horrible is that? Whether these people are responsible or not, the facts are horrible.
Yeah, absolutely a devastating story, as you said, just to know that this man is dead, his wife shot in the leg, and all based on the allegations, what seems to be in a botched robbery. So it's just absolutely an absolute tragic event. So is that how we get to the death penalty here, Michael? Because usually under state statutes, you need some sort of aggravating factor to take a case from just a murder that might get you a life sentence to the death penalty. Can you explain that to our viewers?
Yeah, it seems to me, you're absolutely right. To get it to a death penalty situation, usually they look to an aggravating factor like premeditation. Was it a contract shooting? Was it particularly hostile and aggravating? The age of the deceased. To the extent that this is, and I hate to use the word conventional, but a conventional death during the course of a robbery, it seems to me that it may be a more difficult road to go. But then again, I don't know the facts of the case. I don't know, for example, if any of these defendants are alleged to have made comments prior to shooting this person in the back, which is a aggravating factor in and of itself. This is not any issue of self-defense where they could argue the Marine was using some type of tactic that he may have learned in the Army that scared them, and maybe he became the aggressor, some type of argument. Shot in the back. So that's an aggravating factor. But we have to wait and see what the facts are. But you're right. I'm going to go with being shot in the back as the aggravating factor.
Yeah. Well, it certainly will be interesting as we watch this case to unfold. An absolutely tragic case. While we wait for the Bradsher case to be back live in the courtroom, we do have a report on this case that we are going to be seeing opening statements in tomorrow. So we're going to watch that now. Thank you for joining us this afternoon on the Law and Crime Network. I'm Misty Marris. We are waiting for the Wallace Bradsher case to come back into the courtroom. They are currently on a lunch break, and we anticipate that after the break, we're going to hear more from Judge John Schultz, who has been a very interesting witness this morning. Now, he was supposed to be Cindy Blitzer's supervisor. So this has been an aspect where it appears the prosecution is trying to lay the foundation for perhaps the way that the office was supposed to run, how Cindy Blitzer's time was supposed to be calculated, how it was supposed to be kept, and who was supposed to be overseeing that. Now, interestingly enough, Schultz testified that at some point he became simply too busy to handle those administrative and logistical tasks. So he went to Bradsher. They spoke about it, and Bradsher said, "Don't worry about it. I'll have an administrative person take care of it." Now, apparently, no one was ever assigned to that, and Bradsher had directed Schultz to just approve the time that was in for Cindy Blitzer. Now, this all serves as the basis for the prosecution's case, which alleges that Cindy was permitted to work or permitted to be paid without actually doing any work because she was actually in a full-time nursing program and was not actually performing any work for the office. So, Michael, we still have you here, thank goodness, because we need to talk about this. Now, Judge John Schultz, interestingly enough, he spoke a little bit about the system that was in place and gave the jury and the court a little bit of an idea about the way things are supposed to work, right? So how time is input and when it would be approved and whatnot. And he was supposed to be her supervisor. Well, that really didn't turn out that way. And we're in the midst of the cross-examination by Bradsher of his former colleague and friend, where before the break, we heard Bradsher make the point, aren't you ultimately responsible for doing this? Now, do you think that this testimony is going to have a big impact on the jury? What's the relevance here?
Again, I really don't think there's much relevance to it other than trying to dirty up the case a little bit and maybe trying to show that he's being picked on, that, in fact, the judge knew that she wasn't working and it was all okay with the judge. And the only reason that Bradsher's been charged is for some political reason or for some other type of conspiratorial avenue, and hoping that the jury does something, like I said earlier, called jury nullification, which means they just throw up their hands and go, everyone's guilty and I'm not going to convict anybody here.
Right,
if the judge did something wrong, they let him go. How come they're letting Bradsher go? But that's a two-edged sword, because if you're arguing that the judge knew that she wasn't working and that the judge was okaying it, you are then conceding the fact that she wasn't working. So you're hoping that the jury is going to acquit just because the judge didn't get charged or the judge okayed her not working. But, you know, and I don't know what the elements exactly of the statute are. I don't know if there's some authorization issue here, if the theory is that someone in charge was authorizing the conduct, therefore I can't be guilty because someone was actually authorizing it who maybe shouldn't have. So it wasn't me who was doing it, it was him who was doing it. In other words, I didn't have the ability to authorize her having a no-show job. He had to sign off on that, and because he signed off on it, that's his problem. It's his fault. He knew what he was doing.
I didn't do anything wrong.
Correct.
Because those with have the power to make those decisions said, okay. Well, that's an interesting theory, and I think that's what he's doing here.
And that's why Schultz has come back at it. That's why that whole theory about Schultz saying, well, you know, I complained about it, and he said, no, I'll take care of it. Just sign off on it. Schultz is kind of putting it back on Bradsher's back. Right.
And I think that's actually perhaps a tactic that Bradsher is using, as you said, to muddy the waters, to raise that standard. You know, all you got to do is raise some reasonable doubt, right?
Correct.
So perhaps that's what he's going to use in his closing statement. There's something very interesting, Michael, that you brought up that is reminiscent of what we heard in the opening statements. And part of that is how open the arrangement was. Now, Bradsher had said that in his opening statement, he said, my wife had worked for me for a long time. You know, that it was a very open situation, the fact that she was working on cases with me. We appeared in many courtrooms where I said, this is my wife, you know, she's doing X, Y, Z, while he was picking juries and doing whatnot and assisting in that capacity. Now, he didn't get into when we see the big switcheroo, when the swap comes and how that actually changes. And again, we know that switch was made because Blitzer, he testified that there was an ethical rule barring family members from working directly with them. So in that sense, it seems like Bradsher is going that route, that he's saying, hey, look, this was an open situation. Why would we be so open about it if we were doing something wrong? Do you think that's going to be part of the argument?
I think sometimes what you have to do when things are blatant and the issue is what was my intent, as is always the issue in a criminal case, you have to show the defendant acted with some bad intention. If the theory is I was acting overtly in this, everyone knew, the judge signed off on it, and now all of a sudden they're looking for some sacrificial lamb, and you know it's me because I was the DA in the case and I'm an attractive token to have on their wall. You know, that may be the argument, that this has all been some type of conspiracy against him for people covering up for their own mistakes and realizing they couldn't have let it done, and I'm the attractive out on this. So sometimes you just have to play to a jury's sense of fairness, that although they may have thought he did something wrong, that it's just not, the prosecution itself just isn't right. And that's where the judge's instructions will become very, very important, because the judge tells the jury, certainly when the jury's picked as well, that you can't let bias or you can't let the need, feeling bad for somebody or sympathy to weigh at all in your deliberations. I'm going to give you what the law is, and if the law says that if the person does X, Y, and Z, if you find those elements met, you're supposed to convict. But juries can still do what they want.
Right, absolutely. And a lot of that, Michael, that's excellent insight, because it is interesting to see where Bradsher is going to go in the course of his defense in this action. So a lot of times the defendant is sitting behind the table as his attorney is doing all the work. But here we have a completely different dynamic. We have Bradsher not only as the defendant, but also as the attorney that's setting forth his defense of the case. So that has really added just a fascinating element to watching this trial. Again, we're waiting for court to be back in session. We anticipate that will be soon. In the meantime, we're going to continue with Detective Whitley. Now, he's the lead investigator on the case. We're going to continue watching his testimony, which was from earlier in the trial. Now, this testimony is really very important to laying out the prosecution's case. So we'll continue with that while we keep an eye on the courtroom, and we'll bring you back live the moment they're in there.